Thank you very much. Before we bring up the opposition witnesses, I'd also like to commend you not only for bringing this forward, but I think for how hard you've worked to really attempt to nail down solid definitions and to work very hard on the various provisions of the bills and the bill, and your willingness to work with everybody in crafting a good, solid measure here. I want to just ask a couple questions about the specific provisions here. The patron responsibility portion of the law, California has had long-standing judicial doctrine of comparative negligence, which basically means that in the tort realm, that a court is required or a jury is required to adjudge the comparative fault of parties when it comes to determining the outcome of a lawsuit when there's any kind of accident in any kind of area. What is the relationship between your patron responsibility language and that doctrine of comparative negligence?
The goal and the effort, and the original draft did not reflect it as clearly as I had intended, is to point out where the patron's responsible for those normal and sensible things that are listed, but then to be sure that it does not in any way affect that standard, that responsibility that the industries have to operate safely. And in fact, the paragraph we've added as a result of consultations with the consumer attorneys and Kathy Dressler includes on page 2 of the amendments memo, item 5, Amendment 5, it says, any warning or instructions provided to a patron by the owner of the permanent amusement ride do not abrogate, limit, modify, or otherwise affect any potential liability that's otherwise affordable at law. And so I think it just will assist in helping patrons understand their level of responsibility, but not, if there's co-responsibility for an accident, take away from the company's share of that responsibility if they have such.
Okay. Thank you. The other thing that I appreciate what you've done with today's amendment, Mr. Torlakson, is that I think you have more clearly defined the definition of serious injury, which again is key because that's what triggers the reporting requirement. The prior version sort of defines serious injury in the negative, and this defines it in the positive. And I think that's it's very good movement here. I would just point out as well that as the bill proceeds, there are our health and safety code and penal codes actually contain definitions of serious injury as well for purposes of their codes. You may just want to look at them to see if there's any part of those definitions.
Appreciate that suggestion. We certainly will do that. Your earlier suggestion to deal with the negative to the positive on the definition has been helpful, and we'll proceed to look at those other sections.
All right. Thank you very much. Let's call up Mr. Marquette. Do you have any questions at this point? Not at this point. Okay, let's have the opposition, or at least those with concerns about any parts of the bill. Thanks for coming.
How you doing? Good to see you. How are you, Jennifer?
Again, I'd ask you to all limit your comments, if you can, to about 3 minutes. Thank you.
Thank you, Mr. Chairman. Excuse my voice.
Okay.
I'm overcoming a Southern California springtime cold. We're not used to all the rain we've been getting there in April down in Southern California, and my nasal passages are reflecting that. So thank you very much for the privilege of being here. I want to thank you and the members of the committee for the opportunity to come and to speak with regard to this legislation. My name is Boyd Jensen. I reside in Riverside, California. I am a member of the Safety Committee of the International Association of Amusement Parks and Attractions. I am also a member of the American Society for Testing and Materials F24 Committee, which deals specifically with the establishment of technical regulations for amusement parks and attractions. And I am a lawyer, practicing lawyer in California, who represents amusement parks, permanent parks, and mobile parks in our industry. I'm grateful to be here on behalf of a group of individuals who've been working with Assemblyman Torlakson. I would like to indicate who they are. if I could, please, for the record. Universal Studios, Bush Entertainment Corporation, Paramount Parks, Six Flags Magic Mountain, Six Flags Marine World, Waterworld USA Concord, Waterworld USA Sacramento, Paradise Island, the Walt Disney Company, Knott's Berry Farm, Farrell's Lost Kingdom, Santa Cruz Boardwalk, San Diego Coaster Company, Scandia Family Entertainment Centers, the International Association of Amusement Parks and Attractions, and the International Amusement and Leisure Defense Association. Now, probably my 3 minutes are gone.
That's okay.
So,
Start from here. Go
okay, thank you very much. First of all, I would like to indicate that I have been coming down here now for approximately almost 5 years on legislation with regard to the amusement park. And I appreciate the efforts of those who have had these hearings in the past. And I really want to compliment.
You can get right to it if you
Okay.
would. I appreciate it. Right to the point.
I'm trying to find Dick
Everyone-
Floyd, and I can't see him around
Everyone's
here,
here-
and I wanted to thank him, you know?
Everyone's
Okay.
here in good faith. Just
Okay.
give us your points.
Well, it's important, I think, because of the past and the hearings we've had, that this committee understand that Assemblyman Torlakson in this last year has come to us and has actually met with us and worked with us and has attempted to work out some of these things, and we appreciate that. And we are in support of anything that can help our industry better itself. And let me give you some of the ideas that are in this bill that we support and feel good about. First of all, safety inspections. It's been mentioned that a couple of set of eyes, additional eyes, might help out. That is something that we're engaged in already, the safety inspection process. And many of the individuals that I represent are inspected in other jurisdictions, and inspections is something certainly that we understand. Secondly, having qualified safety inspectors. This is the first time someone has come forward and wanted someone with experience to inspect parks. And I can't answer the question of the Assemblyman who is not here right now, but who asked the reason why mobile amusements came under the regulation years ago and permanent did not. And there was a hearing process, and hearings were held at Disneyland and Knott's Berry Farm. And the reason is that carnivals come into town and they don't go through any of the building code processes, don't have to meet for permits and other inspections that are required by permanent facilities. And that's why the state chose to regulate them back many, many years ago. In any event, qualified safety inspectors, we appreciate that. Thirdly, the fact of having employee training has already been admitted. There are enormously successful and marvelous employee training programs in all of these permanent amusement parks that I have mentioned, and we understand the state's interest there. Mandating insurance is a fourth area that we understand. And then finally, the fifth area that we are pleased to see in this legislation is that involving patron safety. And I would like to say to Mrs. Nelson, who was here, that we were here a couple of years ago before the Concord entrance incident, and we attempted to introduce some patron safety, as Assemblyman Torlakson has seen fit to include in his bill. Now, there are concerns we still have, though, and let me mention a couple of those. Number one, we're concerned about the overlapping and conflicting levels of state inspection, and it is our hope that sometime in the process we can work with that. I have not had a chance to review any of the amendments that Assemblyman Torlakson has brought to the table here, and I would like a chance to be able to do that in the future.
Yeah, can you define conflicting, you said conflicting levels of state inspection?
Right.
You've got concerns about that. Why don't you tell us what that is, because I don't think that's the number of inspections that's changed in any kind of form in the latest amendments. I'd like to know what is the issue with the various levels of state inspection?
Let me try and explain it this way. If we have an attraction and we bring in the insurance inspector, and the insurance inspector looks at the attraction, he says he wants signs a certain way, or he wants the attraction to operate a certain way. That's one level of inspection. We bring